Welcome to the National Crime Victim Law Institute's Victims' Rights Issue Spotting video. In this video, we will provide an overview of common victims' rights and then walk through a scenario where we practice issue spotting victims' rights issues that can arise when working with survivors who are navigating the criminal justice system in the aftermath of crime. Let's begin with an overview of common victims' rights.
The first step to identifying potential victims' rights issues is being able to identify what victims' rights exist in law in your jurisdiction. Although victims' rights vary from jurisdiction to jurisdiction, common victims' rights include the rights to privacy, to confer, to notice, to be present at critical proceedings, to be heard, to proceedings free from unreasonable delay or speedy disposition, to restitution, and to be treated with fairness, dignity, and respect. The second step is to know the definition of crime victim in your jurisdiction. This is critical because only a person who fits the legal definition of quote-unquote crime victim in your jurisdiction will be entitled to these rights. When you interact with a crime victim, what can you look for to help you identify issues that victim may be experiencing regarding these rights? It starts with knowing a bit more about the rights. A crime victim may experience issues early on in their interactions with the criminal justice system. The right to information is the right to advisement of the existence of crime victims' rights. This right requires system actors who have first contact, from law enforcement to the prosecutor, to provide information about victims' rights to the victim in a way that they can understand. Sometimes this is in the form of a brochure or a victims' rights card. The right to notice is a distinct right. This right is often referred to as the gateway right. The right to notice is at the heart of victims' participatory status, because if a victim is unaware of key moments in the case or proceedings in which those rights are implicated, the victim cannot participate in the system. This right may be implicated in situations where a victim is not timely notified of hearing dates or of the defendant's arrest or release. The language of the right to notice varies by jurisdiction. Like notice and information, the right to confer empowers crime victims to participate in the criminal justice system. The right to confer allows a victim both to gather and provide information about the crime to the prosecutor. This is not a right to control the prosecution, but it does require the prosecutor to hear the victim's concerns. A victim who is not afforded the opportunity to confer cannot meaningfully convey to the prosecutor or ultimately to the court their safety concerns, their hoped-for outcome regarding whether or how to charge the defendant, and what release conditions should be requested in a pretrial release proceeding. The right to confer is also critical to ensure any plea agreement meaningfully factors the victim's rights and interests. Navigating proceedings can be challenging for crime victims, and delays can make the entire process more difficult. Repeated continuances or rescheduled hearings can violate a victim's rights to proceedings free from unreasonable delay. While many jurisdictions have a general right for all crime victims to have proceedings involving their victimization be free from unreasonable delay, some also afford child victims and other vulnerable populations a specific right to a speedy trial in certain situations. We often consider the right to proceedings free from unreasonable delay when we hear the victims who are struggling to schedule time away from work or cope with ongoing stress about proceedings that suffer from delays. The right to protection relates to the victim's right to be reasonably protected from the accused or those acting on behalf of the accused throughout the criminal justice process. This broad right is complemented by other laws that address issues of the victim's physical safety and mental and emotional health. This right is at play whenever the court is considering release or contact conditions, and when information about the victim's identity or location might be presented in court proceedings. A victim's right to protection may be threatened if, for example, the accused is granted bail without certain conditions of release, or the court proceedings endanger the victim by making specific information accessible to the accused, such as contact information. The right to privacy refers to protections involving limiting or preventing access to the victim's personal information. Control over the release of personal information helps to protect victims from being re-victimized during criminal proceedings. This right is often implicated by subpoenas for medical or mental health records, discovery attempts, or the need to safeguard other information as it is appropriate. The right to be present gives the victim the authority to decide if they want to be in the courtroom during the criminal proceedings, whether pre-trial, at trial, or post-conviction, including sentencing, and even probation and parole hearings. Victims may experience challenges with this right if the court prevents them from being present for proceedings or fails to provide the accommodations necessary to be present in a meaningful way. The right to be heard is intended to ensure victims can be active participants in the criminal justice system. It refers to the right to make an oral and/or written statement to the court at a criminal justice proceeding. This right may be implicated if the court does not allow the victim an opportunity to be heard in release, plea, sentencing, parole, and any proceeding impacting a victim's right. One example of the right to be heard is when a victim gives a victim impact statement at sentencing. The right to restitution may help a victim recover from financial harm. Restitution is money paid from the offender to the victim for certain financial losses that the victim suffered as a result of the offender's crime. Depending upon the jurisdiction's statutory or constitutional provision, the right to restitution can be mandatory or discretionary and can entitle the victim to full or partial restitution. These financial losses can include medical bills, lost wages, and damaged or lost property. The right to restitution may be implicated if a prosecutor does not seek restitution at all, or seeks an amount less than the full amount of the victim's losses, or when a court refuses to consider and order restitution during sentencing or a separate restitution hearing. The rights to be treated with fairness, dignity, and respect are broad but meaningful rights. Some combination of these broad rights are found in many jurisdictions nationwide. The right to fairness is understood as a right to due process. More generally, however, these rights are implicated when the system demonstrates hostile treatment, which can include reference to the victim as quote-unquote the alleged victim, derogatory comments about a victim, or unreasonable denial of the presence of a support person to accompany the victim during proceedings, or even a refusal to timely return property to a victim in some instances. In addition to these rights, every state has something called crime victim compensation, or sometimes crime victim reparations. These programs are money paid from the government to a crime victim to reimburse the victim for certain losses incurred as a result of the crime. Recovery from these programs is typically capped at amounts less than a victim's actual loss, and the programs are quote-unquote payers of last resort, meaning victims must seek other avenues such as insurance first. Among the qualifications for these programs are that victims need to timely report their victimization and timely file an application.
Now that we have learned a bit more about some common victims' rights and how they may appear in practice, let's take a look at a scenario to practice identifying some victims' rights issues that could arise. You are a community-based advocate and you are meeting with a client who shares that their spouse was arrested after neighbors witnessed the spouse hitting them. The survivor shares that they have asked the system-based advocate in the prosecutor's office for a copy of the police report, but it has been several weeks and they have not heard anything back yet. What victims' rights might be implicated? You might have identified victims' rights to information, to be treated with fairness, dignity, and respect, to protection, and to confer with the prosecution, among others. Victim advocates and victims' rights attorneys can help victims communicate with law enforcement and prosecutors' offices, and can help ensure that survivors understand their rights and options when it comes to accessing certain information, including copies of police reports. Victims' rights attorneys can also file motions in court asserting victims' rights. Both victims' rights attorneys and victim advocates can also help survivors understand their options when it comes to the right to protection, which may include everything from safety planning to being heard by the court about conditions of release in a criminal case. In addition, both advocates and victims' rights attorneys can help victims who would like to seek civil protective orders. A few weeks later, the survivor calls you because they received a subpoena from the defense attorney seeking access to their mental health and counseling records. What victims' rights might be implicated? You might have identified victims' rights to privacy, to be treated with fairness, dignity, and respect, to protection, and to be heard, among others. In many jurisdictions, these types of subpoenas might also implicate explicit rights to refuse defense requests for victim information, or extra privacy protections called privilege protections. One way both victim advocates and victims' rights attorneys can help survivors prepare for subpoenas is to make sure that they know their rights up front before they receive any subpoenas for their information, so they can be thinking about their rights, know what their options might be, and who they can call for help if they receive a subpoena for their information. And once a victim does receive a subpoena, ensuring that they can connect with victims' rights attorneys who can assist with responding to a subpoena and provide legal advice can be key. The case proceeds to trial, and just before the jury is called into the courtroom, the defense attorney asks the court to order that all witnesses in the case, including the victim, be required to remain outside the courtroom until after they testify. What victims' rights might be implicated? You might have identified victims' rights to be present and to be treated with fairness, dignity, and respect, among others. Victim advocates often talk with survivors about their rights and options before they decide whether they want to attend court proceedings. By sharing information about what to expect at a hearing or a trial, where a proceeding will take place and how long it will be, and learning whether a victim has safety concerns about being present, an advocate can help a survivor make an informed choice about exercising their rights. Sometimes it can be helpful for either the prosecutor or a victim's rights attorney to file a motion in advance asserting the victim's right to be present, and any other rights, such as rights to support persons or accommodations, so the court can rule on them and all legal arguments can be made and settled in advance. That way, the chances of the victim experiencing an unexpected surprise at the courthouse can be minimized. Victim advocates and victims' rights attorneys should also be sure to plan in advance in case motions or issues arise unexpectedly at trial or in a hearing, as they did in the hypothetical. Planning in advance helps ensure a victim knows how they will be supported if their rights are implicated during a court proceeding. The plan might include the advocate communicating with the prosecutor, if the victim doesn't yet have an attorney, to ask for a break so that the victim can consider their rights and options and decide what they would like to have happen. Or, if the victim has their own attorney, their victim's rights attorney communicating directly with the court. As much as filing motions in advance can help minimize surprises, victims and victim services professionals should feel prepared to address the unexpected. The defendant is convicted, and a separate hearing is scheduled for sentencing. The survivor brings an envelope with receipts to your office and indicates that they have been paying out of pocket for therapy since the domestic violence incident occurred, and that they recently received bills in the mail from the hospital for their medical treatment. They have had to miss several days of work as well. What victims' rights might be implicated? You might have identified victims' rights to restitution and to apply for compensation, among others. Talking about victim compensation as a potential option for financial support is something that should often happen early on in a case, as a conviction is not required for an eligible victim to seek compensation funds to assist with some types of expenses, such as medical expenses and therapy costs. Victim advocates often help survivors navigate the process of applying for compensation benefits early in a criminal proceeding. And although restitution is not ordered until the very end of a criminal case, after a conviction, this is also something that should often be discussed early on as well, so victims know to save receipts or other documentation and are prepared to discuss the out-of-pocket expenses they incurred as a result of the crime. Victim advocates can help victims compile documentation and communicate with the prosecutor about restitution. And victims' rights attorneys can assist survivors in filing motions with the court arguing that restitution be ordered for the full amount of their economic losses. And in cases where plea agreements are being considered, knowing a victim's expenses early on can be helpful in ensuring that restitution is not overlooked or minimized during that process. Identifying victims' rights and thinking proactively about how those rights can be asserted by a victim, either on their own, with the assistance of a victim advocate, with their own victim's rights attorney, or with the assistance of a prosecutor, is key to ensuring both that victims know and understand their rights and that they have the support they need to make sure their rights are respected. Please visit NCVLI's website for additional free resources and information about victims' rights.